Welsh-Levin, your Southern California real estate attorney. At SoCal Realty Law, I am the lead attorney, and we protect the value of real estate investments by removing unwanted tenants. And that's one of the things we do. We also conduct successful transactions and pursue justice for property owners who were harmed by others. So primarily, we are a plaintiff's law firm. We file the lawsuits. We do some defense litigation, but when we do litigation, usually we are on the plaintiff's side. And so that can be very exciting for us. We have currently 4 attorneys and many other staff, 3 paralegals, and supporting staff. So we are always very busy and ready to take on new matters. Today, we're going to discuss what a landlord needs to run a successful rental business. So I'm going to share my PowerPoint here. Okay, you should be able to see the PowerPoint, what a landlord needs for a successful rental business. I'm going to cover topics including leasing applications, lease compliance, insurance, both homeowners and rental insurance, keeping good accounting of rents, issuing notices to tenants of all kinds of notices, best practices for moving in and moving out, trying to, and I'm sorry, and I will tie that into handling security deposits. So when I present on these topics, I'm going to be explaining what the purpose is of each topic, what purpose it serves, why it might make a landlord more successful if you follow the specifics, and then the methods of achieving success under that particular topic. All right, so first of all, let's talk about the start of a tenancy. It all starts with a leasing application. It's important to take a leasing application from a tenant, and usually it's in a written form of a questionnaire that asks for personal information of the tenant, including information that you would use to pull a credit report. It should request references from prior landlords if they have any, and if they don't, then you would want to include some reference to someone else that might be a good reference for them. So the purpose of the leasing application is to make sure to adequately screen the potential occupant of your property. The best way to avoid ending up in court is by making sure to do a very thorough and diligent job of screening your tenants before you offer them a lease agreement, and then acting very diligently throughout the tenancy to respond to the tenants once they move in. So for the leasing application, you want to make sure to follow the law as it is today. In 2025, we had a change. The change is that if you are accepting lease applications and charging a fee, you either have to return the fee once you choose who you're going to lease to, or you have to have a procedure in place where prior to taking the leasing applications, you tell the applicant what you are screening for. What are your things that you're looking for in the application? And then you need to make sure to keep track of the order that the applications are turned in, and you must accept the first applicant who meets your list of requirements. So in my opinion, especially for smaller landlords, it's easier to just return the fees if you're charging the fee for the application rather than having this policy in place. But for larger landlords, it is actually better to, if you're taking those fees, to make sure that you have this procedure in place, and that once you select the occupant, you maintain the records of how you selected that occupant and the time stamps for when those applications came in. It's important to run a credit check. I think that's pretty clear. If somebody has bad credit, they're probably not going to be a good rent payer. But in addition to the credit check, it's really important to make sure that you pull the additional part of a report that includes judgments and eviction cases. Most of the time, if you see that somebody has prior eviction activity on their report, they are probably not going to be a good tenant. Although you might look at the age of the case that was filed against them or the age of the judgment and see if their references will confirm that since they had that problem with a prior landlord, they have redeemed themselves and been a good tenant thereafter. But if those things are recent or if there are many of them, I would steer clear of the applicant. It's important also to know when you're checking references, oftentimes when we have filed an eviction, we settle the case. When we settle a case with a tenant, we do not take a judgment against them, and the agreement that we enter with the court extends masking. Extend masking is a technical term that we use in California courts where eviction cases are masked for a certain period of time, meaning that they do not show up in public records. So when a tenant agrees to move out of the property and settle the case, that is usually a good option for the landlord. And the compromise is that we agree to extend the masking so that that case does not become a part of the public record. So it's a good factor to help us get tenants out, to help us, get them to agree to move out without facing the risks of having a trial and the problems that might come up at trial. But at the same time, it can be a disadvantage for future landlords because that case won't show up. So when you contact the tenant's references, if you reach a landlord that gives a very neutral and non-communicative response to your inquiry, you might be able to read between the lines that maybe that landlord has also agreed to provide a neutral reference, because part of the settlement agreements that we often enter into, the tenant attorneys negotiate a term into the agreement that says that the landlord must give a neutral reference. So screening those references, calling the applicant's references is very important. 4 simple questions. It's very easy. These calls only need to be 5 to 10 minutes long. Do you know this person? Did they pay their rent? Did you have any problems? And would you rent to them again? Those 4 questions should bring out a lot of information that is either clear and concise because the landlord says they were great, I'd rent to them again, they always paid their rent. Or the landlord says, I can't really tell you anything. I can't really explain why I can't tell you anything, but I can't. And reading between the lines, that would indicate that there was a problem. But the first question is, did you know this person? So if the person is the reference didn't really know the person or can't really provide you with any information, you don't need to read between the lines there. They just don't know anything. So you might want to ask for someone who did know or who was there during that person's tenancy. Checking those references is very important. And then when you're taking leasing applications and deciding on applicants, be very careful about your communications directly with the applicants. You want to avoid claims of discrimination. We get a lot of landlords who are facing complaints with the California Civil Rights Department, and that used to be the Department of Fair Employment and Housing. When a tenant files a complaint against the landlord, the Civil Rights Department issues a letter and the landlord has to provide a response. And then we go through a process where the department investigates. And it's time consuming and can be expensive. So this is something to avoid. So how do you avoid claims of discrimination? Be very careful about what you say about the source of the tenant's income, because landlords are not allowed to discriminate against a tenant or refuse to accept a tenant based on them being Section 8 or having a VASH voucher or having any other kind of income. So that cannot be a reason to reject the applicant. Also, if they have an animal, the screening process should ask whether they have a pet. And if they say, I don't have a pet, but I have an emotional support animal, you might also ask a question, do you have an animal? So that then that would elicit the disclosure of an animal. An emotional support animal is not a pet, and you can't call it a pet without creating a presumption that you might be discriminating. So emotional support animals are an indication that the tenant is disabled, and refusing to rent to someone with an emotional support animal means that you're discriminating against a disabled person. In prior webinars, we've talked about how to deal with emotional support animals, tenants with emotional support animals, and how to engage in confirming that this is an emotional support animal. I'm not going to go into all those details right now, but when you engage in that process, it's important to do it correctly so that it doesn't appear that you're discriminating. We have many, many protected classes to be aware of. You cannot discriminate against someone for their race, color, religion, sex, gender, marital status, family size, military status, medical condition, national origin, including their use of language, whatever language they use, disability, age, immigration status, and in California, we have a catch-all that you cannot discriminate against someone for any other arbitrary characteristic. So the best way to avoid claims of discrimination is by preparing a written policy for reviewing rental applications, and then having an attorney or another knowledgeable professional review it with you to confirm that as long as you follow this policy, it's not discriminatory, and maybe adding in some additional steps to document and make sure that it's not discriminatory, and then make sure to stick with the policy. And then the last question is, should you document the reasons for choosing or rejecting a particular applicant? And as an attorney, I advise clients in sometimes to document it and sometimes not to document it. How do I determine which advice I give? Usually it's based on what the reason is. If the reason for rejecting the person is borderline, potentially, if somebody got a hold of a document that says this is the reason that the landlord rejected this applicant, that it could be used against them, then I would say don't put it in writing. However, if it is a good reason and it supports the fact that this applicant was less qualified or was not appropriately qualified, then I would put it in writing. Okay, so the next subject is compliant lease forms. If you've seen prior webinars, compliance is the key. We screen every single landlord for compliance, and the minute they walk in our door, we look at their lease and we can tell them within 15 minutes whether the lease is in compliance with the law or not. And I would say that about 80 to 90% of the landlords who hire us for the first time are not in compliance. So the purpose of having a compliant lease form is to make sure that the landlord or the property manager are protected by the terms of the lease agreement and that those terms are enforceable. So if you're out of compliance, in some cases, your lease is not enforceable. So if that tenant stops paying rent, we can't enforce the rent until we are able to bring the lease into compliance. And that causes substantial delay and losses for the landlord. So how do you have a compliant lease? How does a landlord manage to stay in compliance? Having an attorney prepare your lease form is a good way, or having an attorney review it. Standard lease forms will generally cover all of the necessities, such as the time time limit, the term of the lease when it starts and ends, the amount of rent, the amount of the security deposit, and who pays for what as far as utilities, landscaping. But many of the lease forms that you might find online, they're sparse. They don't necessarily have many of the other things that I recommend making sure in your lease. That includes having the tenant maintain a policy of renter's insurance. Landlords should talk to their insurance representative and have a good insurance representative to talk to who will advise them of how much coverage the tenant should maintain. Whether the tenant should maintain coverage only for the contents, their own personal belongings that they bring with them, or whether the tenant should maintain full coverage, including the full structure of the building. And this may be affected by what kind of policy the landlord has. So I've been told that under some policies, if a tenant causes a fire and the insurance policy, their renter's insurance policy is not enough to cover the full structure of the rental property, then that landlord might not be covered for the structural damage by their own policy. I think generally the landlord's homeowner's policy will cover for fire or for, whatever it's meant to cover, even if it's caused by the tenant. But I have been told by an insurance representative or two that that may not always be the case. So having your insurance policy reviewed and then having a recommendation as to how much coverage the tenant should maintain is very important. Also, make sure to include in your lease an addendum that complies with the California Tenant Protection Act, as well as any local laws that require similar disclosures to the tenants. So the California Tenant Protection Act is statewide, and it requires that your lease contain a disclosure to the tenant, a notice that states whether the tenancy is exempt or not exempt from the Tenant Protection Act. If you're in the city of San Diego, the city has its own ordinance that includes the California Tenant Protection Act and the City of San Diego's ordinance, and the disclosure language is specifically set forth in the ordinance that must be included in your lease. There's different language for a tenancy and a property that is exempt from the tenant protection ordinance, and language for a property that's not exempt from the tenant protection ordinance. So a landlord needs to make sure to understand whether their property may be exempt or not exempt and incorporate the appropriate language into the lease. It's also important to know that if your property is like a single family residence and you own it in your own name, you still need to comply with this law, because unless you have given your tenant notice that the property and the tenancy is exempt from tenant protection laws, it is not exempt. So unless you claim the exemption and that you're entitled to claim the exemption, you are not exempt. Along with the City of San Diego law, there is a San Diego Housing Commission tenant guide that needs to be provided. This is for non-exempt properties, but we always provide it with all of our leases because it's good information for the tenants to have, and there's no reason for them not to receive it. And the city's ordinance states that if you are not in compliance with the ordinance, then you cannot issue any notices to the tenant. It states any notices that are issued to the tenant when you're not in compliance with the City of San Diego's tenant protection ordinance are void and unenforceable. So in order to issue a notice to pay, we have to first bring the lease into compliance. It has been delaying many of our evictions. Also, for non-exempt properties, it's important to include in your lease form, make sure that when Well, make sure to include the City of San Diego buyout disclosure. This is a disclosure that needs to be signed by the tenant and the landlord and maintained by the landlord. I recommend putting the disclosure in your lease, and it's a disclosure that tells the tenant that the landlord may offer to buy them out of their lease. It informs the tenant of how much the landlord is required to pay, among other details that are required. So there's specific language that the City of San Diego's ordinance requires you to disclose to the tenant before you can discuss a move-out agreement or a buyout agreement. A cash for keys agreement is another term that we use for a buyout agreement. And so that's for non-exempt properties. Also for non-exempt properties, the lease has to have a statement that the landlord has the right to move in. And that's required if the landlord intends to use that as a reason to terminate the tenancy at a later date. We often use a 60-day notice to terminate a tenancy based on the landlord taking occupancy or using it for occupancy by their immediate relative, their child, parent, grandparent, various specific closely related individuals. But if your lease does not have that in it, you can't use that reason in the City of San Diego, and that holds in other local jurisdictions as well. And then make sure that any rent increases, any addenda to your leases, or any new leases that you enter into with the tenant are in compliance with California's rent cap. Right now, the rent cap for non-exempt properties in the county of San Diego is 8.8%. Make sure not to exceed that. It changes every year. And then also make sure to include in all of your leases a notice of the tenant's right to a final walkthrough. You can issue this notice at any time, but it's easiest to just make sure it's in your lease, so then you don't have to remember to do it later on when the tenancy is ending. You have to, as a landlord, provide the tenant with notice of their right to a final walkthrough and provide the specific language from the statute stating that the walkthrough must happen within the last 2 weeks of the tenancy, and the landlord has to provide the tenant with a list of defects that they may use the security deposit to fix, and it gives the tenant an opportunity to fix those things themselves. But if you don't include that language, then the landlord technically is not entitled to withhold any portion of the security deposit. And they can be sued in small claims court or whatever court the tenant wants to take them to return the entire deposit. The lease should also include a disclosure of any known lead paint. If the property was built prior to 1978, then that disclosure, lead paint disclosure, is required. But it's also required anytime the landlord knows of any lead paint. The landlord must disclose whether there's any known flood hazard in the area and provide the website where the tenant can go and see what the flood hazard is. The landlord is required to provide a bed bugs disclosure, bed bugs and other pests. And now we have a new law in 2026 where where landlords are required to provide a working refrigerator and a stove in every property. If the tenant wants to provide their own, there's some language you need to include in your lease to notify the tenant that they can, if they're providing their own, and then they decide they don't want to anymore, then the landlord has to bring a new refrigerator. This is particularly for refrigerators, not the stoves, but the landlord has to provide the refrigerator if the tenant changes their mind about providing their own. There are provisions that you can place in your lease about handling security deposits. So it used to be pretty inflexible, but now you can put some provisions in about how the deposit's going to be handled at the end of the tenancy. And finally, if the landlord is providing internet services, they need to offer the tenant an opt-out provision where the tenant can initial and opt out of the landlord's internet services. It's required by law. All right, the next topic is insurance requirements. So maintaining appropriate homeowners insurance and renters insurance. I did touch on this earlier. The purpose of having appropriate insurance for the landlord and the renter are to protect the property from unforeseen circumstances. So as I mentioned, make sure to have an insurance specialist review the homeowner's policy. If a landlord used to live in the property, moves out and now starts renting it, the insurance policy has to change to a landlord's policy. You can't maintain the same policy of homeowners insurance for an owner-occupied property as you do for a tenant-occupied property. And if your property becomes vacant, you should inform your insurance company. I believe there's usually a restriction on how long it can be vacant before you have to change your policy. But you should always be notifying them if there's going to be an extended vacancy. Maintain in your lease, the car form lease has really good language for acts of God. So basically, a major natural hazard, a flood, an earthquake, things like that, that may render your property uninhabitable. If your lease does not contain a provision that lets you terminate the tenancy, then you're subject to California law, which states that the landlord has to fix the property and let the tenant stay there. But if you have proper language in your lease, then you can terminate the lease. And then the issue of renter's insurance, which we already talked about, but what I wanted to mention is make sure that if your lease says the tenant has to maintain renter's insurance, that you obtain proof of that insurance. If the tenant won't give it to you voluntarily when you ask informally, you can issue a formal 3-day notice to cure. And the 3-day notice to cure would specifically say you must provide proof of your insurance within 3 days, or I may terminate this tenancy, because it would be a breach of contract if your lease requires it and the tenant doesn't have it. All right. So next one is keeping a really good effective accounting practices. We find that a lot of landlords who are maintaining just their own property, maybe they have 1 or 2 residential rentals, they are not maintaining a good accounting. And so when they come in and we ask, well, how much rent is due, it's often unclear what the tenant was required to pay. If the tenant has been paying less than what they're supposed to, but the landlord has been accepting it, that can sometimes alter the amount that the tenant is required to pay, because the landlord can actually waive terms of the lease agreement if they don't enforce them. So if a year goes by and the tenant's supposed to pay $1,500, but they've only been paying $1,250, the landlord needs to be aware that the tenant can argue that they waived the $1,500 and accepted $1,250 as the amount of rent due. So by maintaining a good accounting, you would give that to us and we would see, okay, here's the average that they've been paying. And then we would advise the landlord how much we think we should allege in the notice to the tenant, the notice to pay. If we issue a notice to a tenant to pay rent, and then we want to terminate the tenancy, the notice to pay cannot overstate the amount due. What that means is if our notice to the tenant requests $1 more than what that tenant actually owes, the notice is defective. And if we go into court and the tenant raises this as a defense, we will lose the case. So we've had the situation over and over again where the landlord doesn't have a good accounting practice. They don't have a solid accounting to give us, so we take their word for it. Then it turns out as we prepare for trial, we start collecting more and more documents and seeing that what the landlord told us wasn't actually correct. And then we have to start all over. And so everybody loses time, everybody loses money, and ultimately, we just err on the side of putting less than the total amount due. If we're uncertain at all, we go with the lower number. The point is, making sure to show a good accounting helps us calculate whether the rent increases or in compliance, and then ensure that if we do a notice to pay, that it is accurate and enforceable in court. So how could a landlord maintain a good accounting? Using software is the best way, starting with something as simple as an Excel spreadsheet with a credit and a debit column, two columns, one debit, one credit, and the dates of all of the debits and all of the credits. You can use something like QuickBooks or other accounting software. And then these days we've got some really cool online portals. So if you are willing to use online tools, there are tons of new online portals: Buildium, Appfolio, Yardi Breeze, Inago. I don't know how to pronounce that one. That's a free one. There's one called Tenant Cloud that has a free level for, for small portfolios. DoorLoopApartments.com and Stessa. I'm not advertising any of these, but the decision on which one you use, and there are more than just the ones I listed here, but the decision on which one you might use depends on your portfolio size. For example, Appfolio and Yardi Breeze are for larger portfolios, but Inigo and Tenant Cloud could be used for smaller portfolios. Depends on your budget. So if you need a free option, those are available and surprisingly capable. If you have different kinds of accounting needs, some of the more structured options would be Buildium, Appfolio, and others. And then depending on whether your property is commercial versus residential, there are specific programs that cater more to commercial side, because commercial side has things like common area maintenance and more expenses that get charged back to the tenant. So a lot of these have automations, and if you really like to use automations, you might look at some of the ones that provide those kinds of features. All right, so but the point is to maintain really good records so that if you do need to enforce the rent, we are able to prove how much rent is actually due, and we're able to calculate whether the increases have exceeded the rent cap. So for residential properties subject to the rent cap, one great example that has occurred is that the landlord came in and told us how much rent was due, but then once we filed the lawsuit and went back through the history of rent increases, there was a rent increase in 2021 that was a 10% rent increase, but at the time the landlord was subject to a 9.1% cap. And we could have fixed that very easily in the notice to pay by simply discounting the overpayment, because technically exceeding the rent cap does not invalidate your notice or your lease. It just creates liability that you have to pay that money back. But if we issue a notice to pay and rent has been charged that should not have been charged, then we need to credit that on the notice to pay because we don't want it to overstate the amount due. So technically that tenant doesn't owe all of that rent because they get a credit from the overpayments that exceeded the rent cap. So if we have a good accounting, we can go back through the history and confirm that all of the increases have been appropriate, and then we can save time and money by making sure that our initial notices are accurate. All right, so speaking of notices, tenant notices and enforcing the lease. What is the purpose of tenant notices? Either enforcing the existing terms of a lease agreement or changing the terms of a lease agreement. So it's important for a landlord to either have their own forms that they can ensure are legally compliant and that they know how to fill them out properly, or to make sure to have an attorney who will either review the notices before they're served or will do them for the landlord or property management company. So a notice of change in terms of tenancy is an important one. We use those all the time. That's a 30-day notice, and it can only be used, you can only change the terms of the tenancy when the tenancy is month to month. So you can't change the terms if you have a 1-year lease that has not expired yet. But you can issue a notice 30 days before the end of the 1 year, so that the change takes place after the lease expires. Then we have notice to pay, notice to cure. Those are usually 3-day notices, but we also need to make sure that the lease doesn't alter that, because a lease could say you have to serve a 5-day notice or a 10-day notice. So 3-day is the default, but some leases can alter that. Then we have 30 and 60-day notices. So if we are terminating a tenancy and it is not the tenant's fault, it's a no-fault eviction, we would have to use a 30-day or a 60-day notice. How do we know which one? It depends on whether the tenant has been there for more than 1 year. So once the tenant's been in the property for more than 1 year, we have to use a 60-day notice instead of a 30-day notice. These notices oftentimes have to include relocation assistance. So for properties that are not exempt from tenant protections, the state law requires 1 month of relocation assistance, equivalent of rent, 1 month. And then, for example, the city of San Diego requires 2 months of relocation assistance, or 3 if the tenant is disabled or elderly. So that's important to be aware of. And then if you have Section 8, VASH voucher, or any kind of federally subsidized tenancy, federal law requires a 90-day notice and just cause. So in order to terminate a Section 8 tenancy, you have to do a 90-day notice and state very clearly in that notice a just cause that qualifies under the provisions of law that apply to Section 8 tenancies, among other federally funded tenancies. Those are all governed by HUD rules, Department of Housing and Urban Development. And then I mentioned before the notice of right to final walkthrough. If it's included in your lease, you don't need to send a new one. But if you have a lease that doesn't include the statutory notice of the tenant's right to a final walkthrough prior to moving out, then you need to make sure to give that to them prior to the last 2 weeks of their tenancy. It does not apply if the tenant is being terminated for their own fault. So an at-fault eviction, you don't have to do the final walkthrough, but if it's a no-fault eviction, or if they are giving notice and moving out on their own, you have to agree to do a walkthrough within the last 2 weeks of the tenancy and give them a list of the things that you see that are in plain view that you intend to use their security deposit to fix. Yeah, so maintaining the terms of the lease, using these kinds of notices. What's important is to be diligent in issuing the notice. If the rent is late, make sure to give the 3-day notice. You don't have to evict the person. Usually they will pay. If you give a 3-day notice, you only have to accept the rent within the 3 days. You have the option to accept it after the 3 days expire. And sorry to lay on all the details, but it's also important to know that the 3 days do not include weekends or holidays. So a 3-day notice served on the Friday before President's Day weekend is effective on the following Tuesday. So Tuesday, Wednesday, Thursday are the 3 days of that notice. And then you would not be able to issue a notice to quit until the following Friday, which again doesn't run on weekends or holidays. So then you'd have the following Monday, Tuesday, Wednesday for the notice to quit, and then you might be able to file an eviction the following Thursday. So that's 2 weeks from when you initially serve the notice. All right. And the question whether you should serve notices on your own. If you're a landlord and you feel confident that your leases are in compliance, that your notices are in compliance with the law, is it okay to serve your own notices? Yes, you don't have to use a registered process server to serve notices. We only have to use the registered process server to serve a lawsuit. So you can serve your own, but it's important to properly document it. I'm not going to go into the details of properly documenting the service, but if you would like to know more about how to serve notices, we can provide you with some detail on that. All right. Don't forget there are new requirements for move-in and move-out documentation. It's very important to, the purpose of this is to document the property condition and preserve the landlord's right to withhold damages from the tenant's security deposit. So if you don't follow this new law, which went into effect June of 2025, you cannot withhold any money from the security deposit. This new law requires photographs at the time of move-in, photographs at the time of move-out, and post-repair and cleaning photos. So you need to document the condition of the property at move-in and the condition of the property at move-out, and then after you've made those repairs and done the cleaning, you document that as well. The photos have to be delivered to the tenant if any deductions are made from the security deposit. This applies across the board for all landlords. It's also important to document in writing what you see. So we have like the California Association of Realtors memo form, move in, move out checklist. Any kind of checklist will do, but when you do that final walkthrough, you have to provide a list to the tenant. And we also like to see lists of the documentation of the damages at the time of move in and move out. And then maintaining those photos and those documents in a safe place is very important. Make sure to upload them to some sort of digital storage. Don't maintain them on your phone in case something happens to your phone or you have trouble finding them in the future. All right. Handling security deposits is, some things have changed. Much of it is still the same. The purpose of these rules is to make sure that the landlord has the right to withhold damages from the tenant's security deposit. If you're not in compliance with this law, with all of this is basically Civil Code Section 1950.5 and Civil Code 1950.6. If you're not in compliance with this statute, then you are not entitled to withhold any portion of your tenant's security deposit. You are still entitled to your damages if they do damage to your property or if they don't pay their rent. You just can't take it out of the deposit. And if the tenant takes you to court and you're not in compliance with this statute, then the court will award them their deposit back. But similarly, you do have the right to counterclaim in small claims courts. You would want to still allege to the court that they owe you the damages and hope that you also get an award for your damages, and then it washes it out. Okay, so the deposit can only be used for 4 things. The statute says you can use it for past due rent, meaning past due, not future rent. If they move out of they terminate their lease early, you can't take their future rent out of the deposit. You can only do past due at the time of move out. Number 2, repairs that are beyond ordinary wear and tear. Number 3, cleaning to return the unit to the same level of cleanliness as it was at the time of move-in. And then number 4, you can use it for restoring or replacing personal property if that's specified in your lease. That includes furnishing, keys, security systems, and other things that qualify as personal property, not fixtures. And for those who might not be aware, you have 21 days to account for and make repairs. So it's 21 days to make repairs and then send an accounting and a refund, along with those photographs and those receipts. What happens is the landlord is busy, doesn't get around to the repairs, and still tries to withhold what they estimate to be what they want to withhold from the deposit. You can do that under limited circumstances. You have to have a written estimate of the amount that you're withholding. And then you have to act diligently to complete the repair as soon as possible. And once you complete it, then you have to get back to the tenant and provide the final receipt for the work that was done to confirm the amount. And then if it was less than what you estimated, you have to refund the difference. So it's important, in my opinion, to just get it done within the 21 days because it's very complicated to try to do it after the fact. And remember, the new security deposit rule is that the amount is limited. The security deposit is capped. You can only charge 1 month of rent equivalent for a security deposit unless, and there are a few exceptions, you can have the tenant advance payment of rent up to 6 months. That's not a security deposit, but it does allow for accepting up to 6 months of rent in advance. You can charge the tenant if there's a mutual written agreement for the landlord to make structural, decorative, furnishing, or other similar alterations. And a landlord who is a natural person and owns no more than 2 rental properties can charge 2 months of rent equivalent for the security deposit. So 2 months if you are a landlord with only 2 rental properties. You, no matter who you are or how many properties you own, you can only charge a service member 1 month of security, 1 month equivalent for security deposit. So that's the new adjustment to the law as of 2025. Make sure to maintain security deposits in a separate account. That's the best practice. You are holding the deposit in trust on behalf of the tenant. You don't have to hold it in a trust account the way that attorneys have to hold money, but just to make sure that it's there when you need to return it, put it in a separate account if you can. All right. Ownership structure, at SoCal Realty Law, we do form LLCs. We don't do full ownership structures typically, but what we advise is that if you want to maintain the highest amount of liability protection and privacy for your investment, you should put the property into at least an LLC. And I'm not a tax advisor, so you need to talk to a tax advisor before you choose what kind of entity. But an LLC is a good holding company. It's not typically a good company to run income through. So you don't want the rental income going through your LLC in California. There are, like I said, there are tax strategies for where you form your LLC and what taxes you owe. An S corp is generally used for receiving income and an LLC for holding property. The challenge that I've seen is that when you transfer your property into any kind of corporate entity, it will invalidate your title insurance policy. So you want to make sure to contact the title company and make sure that you get a rider on your insurance policy to extend the policy to your LLC so that it doesn't negate that title insurance if you're concerned about that. Oftentimes title insurance is only good for your purchase transaction and you don't need it after that, but sometimes it comes in handy. All right. And then other key issues that come up are employment agreements. So you want to have a property management agreement in writing with your property management company and make sure that they are properly licensed by the Department of Real Estate to do property management. Alternatively, if you are having an employee, like a resident property manager, manage your property, you need to make sure to have a written employment agreement with them and make sure that your lease agreement with your resident property manager is also tied in with the employment agreement. So they need to reference each other. They're 2 separate agreements. But if the lease agreement is not contingent on the employment agreement, then if you terminate the employment, that is not going to be helpful in getting them out of the property. We'll still have to treat them as a regular tenant and terminate the tenancy for other reasons. But if they're tied together, then we can use the termination of employment as a means to remove them from the property. All right. So then what else does a landlord need to be successful? Well, if you know a good real estate attorney, it's very helpful. And it is very important to make sure to check in with your legal counsel when you have questions about your lease, your notices. Make sure that we can save you time and money and protect the value of your investment. All right, so thanks everyone for listening. We do have some time for questions. Let me see what I have in the chat here. And then, like I said, this isn't intended as particular legal advice, so give us a call or check in with us if you have particular questions. So here, let me see. First question, if your tenant has broken their lease and moved out, should you send a notice to pay the amount due as the unpaid rent accumulates, like once per month until you get a replacement tenant and then send another with the final amount due? So the notice to pay is really only important when the occupancy is still at issue, because it is a means to terminate the tenancy. Otherwise, if the tenant moves out early, they are in breach of contract, and the type of legal action would be a breach of contract claim. So in the event of a breach of contract, the landlord is required to mitigate their damages to find a new tenant, and we call it re-renting it on the existing tenant's account. So, you do your best to find another tenant at fair market value. You credit that new tenant's rent payments toward the remainder of the prior tenant's lease. And only once you have done that do you know what your full amount of damages are for the breach of contract. So at that point, you know whether it's a small claims court matter or you want to go to um, a higher level court, limited civil action or unlimited civil action. But there's no need to send monthly notices to a tenant that's already moved out. By all means, send a demand letter, send one every month, send one every week. Report them to collections and have the collection agency do it. But if you want to get a judgment against them, issuing notice to pay is not necessarily going to help you. Okay, if you've not been able to find any insurance offering renters policies which cover damages caused by the tenant, does anyone know of any? Maybe the tenant's damages would be covered under the liability segment of the renter's policy, except all insurers have excluded that. Yeah, I mean, I'm not an insurance expert, but it's important to know a good insurance representative. Most of them are getting policies out of the same pool of policies, but some of them have different contacts and different types of coverage. Some companies have different types of coverage. I find that an insurance representative, like an individual who will go around and shop what you need to multiple insurance companies, is the most helpful kind to look into. Sorry, I can't be more help with that, though. There are a lot of things that are excluded from coverage. Do move-in photos need to be sent at the time of move-in? No, they do not. They need to be sent at the time when you are accounting for the security deposit. It doesn't hurt to share them with the tenant. There's no reason not to share them with the tenant, although if the tenant should be documenting it themselves. And would we recommend investing the property in an LLC or a trust? So a trust is not an entity. A trust is simply a fiduciary relationship between an individual and a property. A trust can be well, a trustee of a trust can be a member of an LLC, so you can have your property in a trust and an LLC at the same time. But the trust does not protect anyone from liability except after death. So they serve very different purposes. So if a tenant is a senior citizen or a disabled tenant, does the landlord have to give the tenant 90 days notice due to 3 months of relocation assistance, or is it still 60-day notice with 3 months of relocation assistance? It's the latter. It's the 60-day notice. If they've been there more than a year, you have to give them 60 days notice. And if they're elderly or disabled, this is only for the city of San Diego. I don't know any other local jurisdiction that has the same provision. But in the city of San Diego, you have to give them the equivalent of 3 months rent if your property is not exempt from the ordinance. If they've been there less than a year and you only have to give them a 30-day notice to terminate the tenancy, under the city's ordinance, you still have to give them the 3 months of relocation assistance because the city's ordinance kicks in within the first year of the tenancy. That's different than the California Tenant Protection Act, which only kicks in after the tenant has been there for more than 1 year. But again, Tenant Protection Act only requires 1 month of relocation assistance, regardless of who the tenant is or their status. Is the security deposit rule the same for unfurnished and furnished properties? Yes, unfortunately, it is the same rule for furnished and unfurnished. So it used to be that you could charge one additional a month of rent equivalent if the property was furnished, and that is no longer the case. Everybody is subject to the same rule regardless. Let's see. Pet security deposit. So how do you handle pet security deposits? It all goes into the same bucket. A pet security deposit is just part of the security deposit. If the animal is an emotional support animal or a service animal, they're not a pet, so you can't charge a separate pet security deposit. But when you're calculating the 1 month equivalent for the deposit or 2 months for the deposit, a pet deposit is included in that. You can't charge any additional deposit for a pet. Can I provide thank you for the compliment. Can I provide an addendum to the car lease form? Yes, I have that. If you were in last month's webinar, I apologize. I was slow to get the addendum put together, but we have an addendum for exempt and non-exempt properties in the city of San Diego that has all the compliance verbiage you need for the city of San Diego. You can also use it. You can delete the city of San Diego. Well, if you need one for properties outside of the city of San Diego, that's difficult because we need to know what the local rules are, and we're happy to draft an addendum to match your local rules, or if you're just subject to the state of California rules, that one's easy. We've got that ready for you. And yeah, so if you're in the city of San Diego, I will make sure to resend those addenda with this video, but also, reach out, use the email address here and let us know that you want that, and we'll send it right out to you.